As we come on the air, the plot thickens in a case that seems all but destined to land before the Supreme Court. The open question of whether the 14th Amendment disqualifies Donald Trump from being on the ballot, specifically being on the Republican primary ballot in the state of Colorado, and how this question is decided could have ripple effects that go well beyond just the Republican state primary and well beyond Colorado. As viewers of this show know, that bombshell ruling by the Colorado State Supreme Court found that, quote, that President Trump engaged in insurrection through his personal actions on January 6th, and therefore is, quote, disqualified from holding the office of president under Section 3 of the 14th Amendment. Importantly embedded in that ruling was this little ticking countdown clock, giving any party, not just Donald Trump, until January 4th to appeal to the Supreme Court, and saying if anyone asks the Supreme Court to review this case, then Donald Trump's name stays on the ballot until the Supreme Court weighs in. Well, no surprise, the disgraced, twice impeached, 4 times indicted ex-president made a lot of noise after this ruling came out, whining and bloviating and promising to, quote, swiftly file an appeal to the Supreme Court. But then a funny thing happened. While Trump and his lawyers were working on that swift appeal, look who beat him to the proverbial punch: the Colorado Republican Party, who filed their own appeal urging the justices to take up the case and do so quickly. And while Mr. Trump is expected to file his own petition in the coming days, this move by the Colorado Republican Party has a, quote, practical impact, extending a stay entered by the Colorado court while the justices consider the matter. In plain English, quote, that means Mr. Trump will remain on the primary ballot for now. Now, we've seen this movie before, the Republican Party stepping in to help fight Trump's battles, but this chess move by the Colorado Republican Party is yet another toxic reminder of the toxic relationship between the disgraced ex-president and the GOP. But if the Supreme Court does take up this 14th Amendment case, as they are expected to do, those 9 justices will have not just the fate of Donald J. Trump in their hands, but arguably democracy itself. And it's not just this case that appears to be heading to the Supreme Court's doorstep. They have already agreed to review the obstruction law that could impact the federal election interference case against Trump. There's also the open question about Trump's gag order and presidential immunity. And don't forget about Mark Meadows and his efforts to move his Georgia election interference case to federal court, which could derail the criminal charges against not just him, but also Donald Trump. All of that is or could be in play for the Supreme Court, meaning the 9 Supreme Court justices, well, they're in for a very Trumpy new year. And that is where we start today with our panel, Politico national correspondent Betsy Woodruff Swan, plus former lead investigator for the January 6th Select Committee, Tim Heapy, and here at the table, senior opinion columnist for the Boston Globe and co-host of the Sisters-in-Law podcast, Kimberly Atkins-Stohr. Kim, I'm going to start with you. Can you just walk us through the practical effects of what this appeal from the Colorado Republican Party, what it does? It keeps Trump's name on the ballot, of course, obviously, that we know that. But until when? And then, because they've already appealed, does Donald Trump even need to appeal, or are we just going to see more bloviating and whining and promises with no paperwork?
Right. So Donald Trump's team absolutely could file what is called a writ of certiorari, asking the Supreme Court to weigh in. People do that. They can ask for them to consider a different question than the Colorado Republicans do, and that can let the justices decide just what question they're going to answer. So it still doesn't foreclose that possibility, but importantly, it does sort of trigger this keeping of the status quo, which is he is still on the ballot. Now, what that could do is take a bit of heat off the Supreme Court to act quickly. If he were still off the ballot, then that could provide some impetus. But because they built in this in the ruling, I think that was something that this Colorado Supreme Court was aware of. So the Supreme Court can do a lot of things. They can do nothing. They can
do you think they'll do nothing?
I don't. But they can also take up questions that don't necessarily get to the 14th Amendment problem. For example, was the trial that Colorado conducted sufficient? Maybe they can rule on more of a technical procedural ground, or they can take on the 14th Amendment question of Is he an insurrectionist head on? There are a lot of unknowns still. We have to wait to see how that plays out.
You know, Betsy, I want to turn to you because when we look at this question of is he an insurrectionist, and actually, Tim, before I go there, I am struck by the insurrectionist question because the Colorado Supreme Court, it upheld the finding that Donald Trump, quote, engaged in insurrection. Okay, and if we remember what Section 3 exactly says of the 14th Amendment, it says, quote, no person shall hold any office who, having previously taken an oath to support the Constitution, shall have engaged in insurrection. Engaged is the key word there. If we're going to bold it and underline it, and not convicted of a court of law, but engaged in. And I'm really struck by, Tim, that the fact that the Colorado Republican Party didn't really take issue with whether or not he engaged in the insurrection, but what they do say over and over again is that, quote, Congress and Congress alone enforces Section 3 of the 14th Amendment. One, is that true? And what do you think that they're getting at there, Tim? Because the engaged in insurrection piece, I think, is critical to the entire question on the table.
Yeah, so the court has both questions of fact and questions of law at stake, Simone, in this question, right? In order to find that Section 3 of the 14th Amendment applies, they have the factual question of, is there evidence that he engaged in insurrection? And then B, legally, does that provision apply to the president? Did he have due process in the factual finding? The Republican petition to the Supreme Court focuses exclusively on the legal questions, not the factual questions. They don't address the judge's finding, the trial judge's finding, and then the affirmance of this by the Colorado Supreme Court that there is evidence that the president engaged in insurrection. But look, as Kimberly said, the Supreme Court can do anything it wants. It can take up the factual question. It can take up the very legal questions or other legal questions that are raised by the Republican Party. The Supreme Court typically takes cases where there's a conflict among lower courts. We have that here because other states have not done as Colorado has done and kept the president off the ballot. Or if there's an important issue of constitutional law, which clearly there is here, the interpretation of the statute. So I think Kimberly's right. The court is going to take this case. Exactly what questions they choose to address and how they come out is a much more difficult thing to predict.
Very difficult to predict. You know, Betsy, the lawyers who filed the Colorado Republican Party petition, they cited a, quote, avalanche of similar cases being brought across the country. And as Tim just noted, I mean, they're not wrong. There are at least 16 other states beyond Colorado that currently have pending legal challenges to the former president's eligibility under the 14th Amendment. Betsy, do you think we're looking at a domino effect across the country, no matter how the Supreme Court rules, especially given the fact that they may not weigh in for a while?
There's no question that the Colorado Supreme Court's ruling has played a significant role in shaping elite legal opinion about this 14th Amendment question. They were essentially the first penguins off the iceberg when it came to a judicial body saying that this 14th Amendment argument against Trump actually has weight, actually deserves to be taken seriously, actually ought to change the way things are operating as we head into the 2024 election year. Prior to the Colorado Supreme Court ruling, I think most legal opinion commentators, particularly folks in the center or who lean, of course, onto the right end from the more originalist perspective, had a lot of skepticism, a lot of eye rolling toward the substance of this argument. But the defense of it that the Colorado Supreme Court made really added a lot of credence. And we've seen, you know, in the days since that ruling came down, more conservative legal experts saying, actually, these Colorado judges have a point. Actually, there's something here to be taken seriously. And I think the fact that Colorado has now taken this step is something that's likely to provide certainly much more legitimacy to these plaintiffs and all these other states as they had before, you know, a significant number of other judicial bodies making the same argument.
I think the filings and reading them are so important, especially the opinions. I have the Colorado GOP filing right here. I want to read something else from that filing. Tim, it says this, quote, unless the Colorado Supreme Court's decision is overturned, any voter will have the power to sue to disqualify any political candidate in Colorado or in any other jurisdiction that follows its lead. This will not only distort the 2024 presidential election, but will also mire courts henceforth in political controversies over nebulous accusations of insurrection. Tim, does that legal argument hold any water? I used to work campaigns for a long time, and it was a regular occurrence that folks would be removed from the ballot via court proceedings.
Yeah, that statement or that prediction is true now, Simone. It's possible for any citizen to go to court now and either challenge the results of the election. The president himself and his campaign did that 62 times after the 2020 election, completely unsuccessfully, or even thereafter, invoking Section 3 of the 14th Amendment. That status quo is present regardless. The issue is that litigants need to have facts that support that. And while a lot of people could rush to the courthouse to try to disqualify candidates from the ballot, there needs to be evidence of that person engaged in insurrection. And that's what is unique about this case. I don't personally fear that there will be a rush of litigation because the facts here are so unique. It's just almost unprecedented that you have this degree of a factual attempt to prevent the transfer of power, stoking the insurrection as we saw on January 6th with respect to this candidate. So sure, it's possible that there will be additional lawsuits brought in subsequent years, but all of them will depend upon facts.